Hello, everybody, and welcome to the next edition of the Butte County Library REACH Financial Literacy Workshop Series. And today we're going to be talking about estate planning. My name is Jacob Arbogast. I'm the director of the Financial Wellness Clinic at CSU Chico, and I've been hosting the series of financial literacy workshops for the last few months. And so we've gone over quite a few topics so far. We've covered things like how to start financial planning, the basics of a budget. We've talked about investing, we've talked about insurance, we've talked about all kinds of different topics, how to talk to kids about money and New Year's resolutions related to money and all, fun things. And now we're kind of getting to the point where, okay, let's look at the future and maybe some more long-term planning. We talked a little bit about insurance before, and so that was kind of long-term planning as well. And retirement planning, that's long-term. Now we're looking at estate planning, and estate planning is what to do with all of your property at the end of your life, right? And so it's not something that's, for a lot of people is not fun to talk about, but it is important to talk about because we want to make sure that we set up our it's called an estate, but our property, we want to make sure our property and our assets are left to people or charities or whoever it is that we want to leave them to. We want to make sure that it's done correctly, the way that we want it to. We want to make sure our wishes are carried out appropriately, and we want to make sure that there's not any kind of burden on our family that they have to figure out how this is supposed to go. We don't want them fighting. Like, we just want to everything be nice and easy, and we can do that with proper estate planning. And so that's what we're going to talk about today. First things first. Oh, let's see. There we go. This is a workshop series from Butte County Library's REACH program, and the REACH program covers all kinds of topics for economic empowerment, things like job searching, things like starting your own business. This series in particular is the Financial Literacy Economic Empowerment series, and where we talk about personal finance topics. So I highly encourage you to go to buttecounty.net/BC Library and search for the REACH program. You can see a calendar there of all the different events that are coming up. The financial literacy section is every Friday. However, there are events happening nearly every day of the week across the board of all kinds of economic empowerment topics. So I recommend you go check it out, see about all the other cool things that are going on there. Also, because we're talking about legal topics in this section, I need to make sure I have a disclaimer. I'm not an attorney. I am a financial planner, but I'm not your financial planner. So I want to make sure I'm very clear that I'm not giving you advice in this workshop or in this series. I'm just telling you some things that you might want to consider. And especially when it comes to some of the topics I've talked about before, like investing and insurance, and now estate planning. Those are topics where there are professionals that you can hire who really know their stuff about these topics. And although I feel pretty confident in my own life to be able to talk about these things, I don't represent you. And so just because I say something in this video does not mean that that is in your best interests individually. I don't know you. This is just a recorded video, right? And so I recommend especially when it comes to estate planning today, if you're not sure about any of these topics, or you think you want to know how they work best in your given specific situation, I recommend reaching out to an estate planner, right? There are estate planning attorneys who can put together things like trusts and a will and any other kind of legal scenario that you might have going on. They might be able to tell you the best cases for that. Plus, there's some tax considerations when it comes to estate taxes, and there's some long-term financial planning considerations as well. And you're going to want somebody to talk to you who knows your specific situation. And this is just general advice for educational purposes only. So let's start with, what is an estate? The word estate makes you think of like a castle, or some big, large, multi-acre property, those kinds of things. Estate is just a generic term that we use to mean all the things that you own when you pass away. And it can be cash, it can be intellectual property, it can be physical property like cars or your house. It can be a lot of different things. You might own lots of different things, and you want to make sure that you leave the things that you want to leave to the people you want to leave them to. And you can imagine when people write a will, they say, leave my jewelry to my son and leave my car to my wife, or what, it could be whatever. that is important to the person who, how they want it to go. And so that is the idea behind estate planning, is we want to make sure that the things that we have are left to the people that we want to leave them to in the appropriate way with the least amount of hassle possible, right? And you might want to include grandkids, you might want to include a charity, you might want to include family or friends involved, or there can be, sometimes there can be, people who aren't, family related to you that you want to involve, or you want to at least leave them something as well, because, you may love them or trust them in some way and you want to leave them something. And that's all great. And that's part of estate planning. So those are all considerations that you might think about. And how you leave property to them is what we're going to talk about today. So first thing is, in estate planning, when you leave something to someone, it's called, the legal process of transferring those assets to someone else. We will call it the probate process. And so when you have a will, it will go through probate, and probate is actually court. And a judge will make sure that you are, or maybe not you because you've passed away, but an executor who it handles all of the transition of your property after you passed away. The executor needs to do things in accordance with the will, and the judge in the court will make sure that the executor is doing that. Someone will be named an executor. You should, if you have a will, you should name an executor that you want in your will, and that person can come and say, look, here is John Doe's will, and he named me the executor of his estate, and so I'm going to take care of the property. And the judge says, okay, that's fine. It's possible that someone could try to contest that if maybe you had multiple wills and they're conflicting with each other. You don't want to have that, but someone could come in and say, no, I should be the executor. And it can get really messy, especially if you don't have a will or a trust or any other information for anyone to base it off of. You can imagine a scenario in which, lots of families start arguing over who, should be responsible, or who should take care of this, property, or who should inherit something. You've probably seen in movies and on TV, families that fight over inheriting assets, especially if there's a lot of wealth involved. Money makes people do things that they might not normally want to do. And so if you have a will, name an executor. The executor can go to the court and say, here's the will, it names me the executor, I'll take care of the assets, I'll make sure Sally gets the car and Johnny gets the whatever. And the judge can say, perfect, let's make that happen. It can take a long time though, because one of the parts of the probate process is, what if you have debts? You die and you owe money to people. Well, you can't just leave all of your assets to someone and just say, screw it, I'm not going to pay those debts. So there is a set period of time where you have to make public that this will is going to be executed, or that's not the right word, that the executor is going to administer the assets within the will, and people who are owed money by this decedent, the person who died, need to come forward or forever hold your peace. That's the kind of way it works. And so they have a certain amount of time. If you owe someone money, that they can come forward and say, hey, the person who died owes me money, I need to get paid before those assets are transferred to someone else. Because if your will says, leave all my money to my spouse or something, then a creditor, someone who is owed money, could say, hey, you can't just leave that to them unless I get paid first, right? In California, there's a little tweak to that. That's not true of every state, where the spouse can inherit all of the property and say, well, I'll just keep paying the debt as it's due, without having to pay the entire debt, right? So in California, we have a rule, what's called a community property state. And so a community property state, not every state is a community property state, but California is. And if you are married, then the assets acquired during the marriage are what's called community property. And so both spouses own the assets that were acquired during the marriage. And there are maybe some minor exceptions to that. And so something like an inheritance specifically to one partner of the partnership of the spouses, that could still be considered individual property rather than community property. But other than a few minor exceptions, most things that are purchased or become property of one of the parties is community property, and so they both own it. And so there's not so much of an issue with wills across spouses. It's more of an issue with when you pass away and your will leaves property to your children or to your siblings or people who you're not married to. Then you start dealing with Okay, we need to pay the debt first, then leave them the remainder, those kinds of things. So an executor is going to be the one taking care of those things, and that happens through the probate process. Occasionally, you might need to publish in a newspaper to say this person passed away, we're going to administer their assets. If you are owed money by this person, you need to come forward within a certain time frame, right? Those kinds of things. So how does the property part work? So the executor is the person who administers the will. And they will say, well, they will read the will, and the will say, for example, maybe it says, leave my money in my bank account to my children. That's a pretty plain, normal, not very many bells and whistles going on there, right? So the executor says, okay, well, I'm going to take this document, and probably from the court, they'll have a document saying that they're the official executor of the will. They'll take the will, the documents from the court, their own identification to prove who they are, and your death certificate from when you passed away to the bank to say, here's the proof that I can get the money out of this deceased person's bank account and transfer it to their, I think I said siblings, or whoever it is that was the person who's supposed to inherit the property. And so they can go to the bank and get that. And it's important that they have the proper paperwork, because the bank's not going to let anybody walk in off the street and said, hey, John Doe died, go ahead and give me his money. They need to have proof. And so if you have the paperwork to back that up, you'll be okay. But the way that the estate transfer works is they have to pay some bills first from the estate. In the United States, family does not inherit debt. And so just because your parents may be in a lot of debt, for example, and they pass away, you as the child are not responsible for the debt unless you co-signed for the debt. Now, if you and maybe your parent co-signed, maybe I can think of an example from my life where I might have had a property, bought a house, joint ownership with my parents, and we were both on it, right? And so there's a debt associated with that we're both titled on. Well, in that case, then I am actually responsible for that debt. I wouldn't be inheriting it from my parents. I would just already be on that title. And so that is different. But if somebody just outright has a debt by themselves and they're the only one on it and they die, then that debt has to be paid from their assets. But let's say maybe there's not enough assets to pay that debt. What happens then? Generally, they're just at SOL, out of luck. The creditor won't be able to collect more than what is there. It also means that the heirs, the people who would inherit from the deceased person, aren't going to get anything, right? All of the money is used to pay the debt, or at least as much of the debt as it can pay, and there's nothing left. Well, then that's it. The creditor is out how much was owed to them. And the heirs, the people who would inherit the money, are also out because they're not going to receive the inheritance anymore. And so that's the downside to it. But the positive is that the heirs are not responsible. And sometimes there's some unscrupulous creditors who might try to convince people that they are responsible for family members' debts. But that's just not true in the United States. It's not a California rule. That's the United States of America. We don't inherit debts here. And there's no such thing as a debtor's prison. That used to be a thing maybe in the 1800s. People don't go to prison. Well, I should say they don't go to prison just purely for the fact that they are in debt. However, you can go to prison for not paying your taxes. So you'd have a tax debt, but that would be more of like an explicit, crime, not necessarily just racking up, credit card debt. You don't go to prison for that. So the executor will file the final tax documents as well. There's some estate taxes that we'll talk about in just a minute. The executor can take care of those documents, and then the heirs are the people who inherit the property after the estate is closed. And they'll go back to the court. The executor will go back to the court at the end and say, hey, I've done all of the things within the will. All the property has been transferred. Everything's taken care of. Let's close this out. And the judge will say, yes, we're done. We will close the estate. And so there are some estate taxes, although in the current tax environment, I'm recording this in the year 2022, we actually have estate tax rules that don't apply to most Americans. And so the way that the estate taxes are set up is that when you pass property through the probate process, you are going to have to pay taxes on transfers. However, there is an exemption, and there's a lifetime exemption of $12.6 million in 2022. So if you pass away in 2022, then you'll have a $12.6 million exemption for property. And so if you don't have $12 million to transfer and leave to someone, you're not going to pay federal estate tax on that. This is a federal rule. So the lifetime exemption means over the course of your entire life, if you've gifted $12.6 million to people over the course of your entire life, then you'll probably have to start paying taxes above that. But if you haven't reached $12.6 million over the course, cumulatively, over the course of your entire life, then you can have an exemption until you reach that. Most people don't have $12 million. And so this means most people aren't affected by estate taxes. I think I remember seeing a survey or some kind of study or something that said 0.04% of estates in the United States are actually subject to federal estate taxes. There used to be a problem with, and this is relevant to Butte County, because there used to be a problem with farmland, agricultural land, having a really high value, but not necessarily generating a lot of cash. And so that would cause, if somebody left the family farm to their kids, that could be triggering of massive estate taxes, right? Because you'd say, well, the value of this farm could be millions of dollars, even though the farm doesn't generate lots and lots of extra cash. You can think of farmers as not being very, cash wealthy, even though they have lots of, producing trees or plants of some kind. And so that used to be an issue, but they actually have specific carve outs for family farms now. So it isn't an issue anymore usually. But that is a scenario in which you'd want to consider talking to an estate attorney. And then now there also is that $12.6 million is per person. And if you are married, you can join that up. And so you can have what's called portability of the lifetime estate tax exemption, lifetime gift exemption, which means if you're a married couple, 12.6 million times 2 is 25.2 million, which means $25.2 million can be left to your heirs after you pass away without triggering any estate taxes. And California as a state, so if you die in California and leave your property in California, California does not have estate taxes as a state. Some states have their own state level estate taxes. And then the 12.6 and 25.2 that I mentioned is federal. However, California has no estate taxes. So another thing to consider on estate taxes is that when someone dies and they leave property to an heir, that heir who inherited the property is the owner now of that property. And if they were to sell the property, they may incur a capital gains tax. Just like if you have a house and it goes up in value and you sell it, you might have to pay taxes on the growth aspect of that house. There are some carve outs, you live in the house for 2 of the last 5 years, that kind of thing. But generally, if you have property that's gone up in value and you sell it for a profit, you may have to pay capital gains tax. When you are inheriting a property, well, let me actually back up. To decide how much capital gains tax you're going to pay, you take how much profit did you make based on what the price you acquired it at and the price you sold it at. And the price you acquired it at is called your basis. You can raise your basis, increase your basis by making improvements to properties or by doing a lot of different things. There's other ways to increase your basis. And the higher your basis is, that means the less profit you made, right? So if you bought a house and you did lots of substantial improvements to it, you can say, I bought it for $100,000, but I've made $100,000 worth of substantial improvements, and now it's a $200,000 basis because I bought it for 100 and I put 100 into it. Then I sell it for 250. That's only a profit of 50, right? So now I have a $50,000 profit. I may pay capital gains taxes on that 50,000 if it was a rental property, I never lived in it, that kind of thing. And so that's one consideration. When you inherit property from someone who passed away, your basis is not their basis. You get what's called a step up in basis, and it's a step up in basis on the date of death, which means the property you inherit is inherited at the basis, meaning your cost of acquisition is whatever the fair value was on the date that the original person passed away. And so if you inherit something from your parents, for example, a house, so I'll use this, I have a thing on here, a $50,000 house in San Francisco. If your parents bought a house in San Francisco in 1950 and they paid $50,000 for it and they lived in it for a long time, actually it doesn't matter if they lived in it or not, but let's say they lived in it for a long time and they died and left you the house and it's worth $2 million on the day that they died, you inherited a $2 million house, you get that step up in basis. And so when you go to sell it, let's say you sell it next year, you live in it for a little while or something, but it doesn't matter whether you do or not. Next year you sell it for $2 million. You acquired it at $2 million because that was the value at which it was the fair value on the date that they passed away, and that's when you received it. So you wouldn't have any capital gains, even though they bought it for $50,000. You get a step up in basis to 2 million because you inherited it at a value of $2 million. And so that's kind of nice because you don't have to pay capital gains on it. It's kind of the offset of, sorry, your relatives passed away, but at least you don't have to pay taxes. You also can choose to take an alternative valuation date. So I said you get the step up basis based on the date of death. There is an option to take a 6-month alternative date. And so you say 6 months later, what is the fair value on that date 6 months after the date of death? And you can use that date alternatively. And there's some rules around doing that as well, but that is also a potential option. And so I wanted to put on here, these are the tax brackets specifically for estate taxes. And you can see they cap out at 40% on an estate greater than $1 million. You would have to already be above $12.6 million in 2022 in order to even trigger estate taxes at all. And if you were married, then you would have to be above $25.2 million to trigger any estate taxes. But then once you're above 25.2, this is the estate tax brackets. And so you can see they can range from 18 to 40%, and there's it's called a progressive tax system. That's not a political term, that's just what it's called, where the tax rate becomes more as the dollar amount goes up. But then above $1 million, you'll be paying 40% taxes on every dollar above that 40% taxes on every dollar above that $1 million threshold. Assuming you were married, that would be actually the $1 million above the 25.2 million that you had already left tax-free. Okay, so that's the basics of taxes. We kind of got the baseline set there. Now let's talk about creating a will. So this is the very first thing that most people think of when they think about estate planning. They think, okay, I should write a will. I should make sure that I leave things to my heirs, my kids, my siblings, my parents, if they're still alive, my whoever, my spouse. I want to leave things to them. I'm going to write that up in a will. And so that's the first thing we consider. Great, perfect start, great way to start. And if you have nothing in terms of estate planning right now, you don't have any will, you don't have any trust, you have never really put pen to paper to think about what you're going to do after you pass away, a will is a great place to start. There's lots of resources where you can get a will done online. You can call an estate planning attorney, and they can help you as well. There's all kinds of different resources available. And in California, there's a few different choices, and I'll talk about the rules for how to create a will. There's a few different choices available to you. One of the myths I thought might be good to dispel is, in movies, we always see things like we all have to come together for a reading of the will, and all the relatives are in the lawyer's office and they have to read the will and tell everybody, and there's a bunch of emotional responses to and people are angry that they didn't get the thing they wanted and all that kind of stuff. That doesn't really happen. That's not real at all. And there's no thing where you can say this person only gets my money if they spend a night in a haunted house, or they, all those kinds of things. That's not real. None of that is real. Generally, a will will be pretty straightforward. The car goes to Susie, the house goes to Johnny, the blah 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 goes to whoever, right? And that's it. That's the whole will. It's not as exciting as movies try to make it seem. But there are some rules, and you have to follow the rules, or else there can be some consequences, right? So what is required? Well, to be a valid will in California, one, you have to be of the age of majority. You can't be a minor. So if you are a minor, then your parents would, assuming, or your guardians would they would be the owners of your property, really. If you're, let's say you're 14 years old, you do not need a will, right? But once you're an adult, you can have a will for yourself. You need to be of sound mind. You need to be able to say that I am creating a will. And there's a phrase that we use called testamentary intent. And so when you create a will, you have to be able to say that you're having testamentary intent, meaning you are writing out what you are doing for your property after you pass away. And you have to have the capacity, in legal terms, we call it capacity, to understand what that means. And so if you're watching this, you probably are of sound mind. But you can imagine a scenario in which somebody might, not really understand what it is that they're saying, right? And it could be for a lot of different reasons. And my example is going to be in my family, dementia and Alzheimer's is a common occurrence when we get to be older ages, right? It's a genetic thing within my family. I probably will experience this when I'm older as well. And so if I am within the time period of my life where I have Alzheimer's and I don't have the ability to really care for myself and make decisions about myself, and I don't have a good understanding of what's going on, I'm not going to be able to create a valid will. But so long as I can do that, as long as I have a sound mind and I have capacity, then I can, right? I need to be over 18. I need to have capacity. I need to make it freely without being forced into it, right? Nobody can hold a gun to my head and say, you have to put me in the will. That's a little bit harder to prove after the fact, but as long as you're doing it freely and not being forced into it, then that's okay. And in California, there's different rules for every state, but in California, it has to be physical. You can't have it just saved to a flash drive, and it's important that it be signed and that it be printed out on paper is probably best. That would probably be the best way to do it. And so, if you can't, it doesn't have to be handwritten, although it can be handwritten. It can be typed and then signed and witnessed. In California, you have to have two witnesses for a typed up, non-handwritten will. Kind of loophole here. If you have what's called a holographic will, which is a completely handwritten will, you actually don't have to have witnesses, but you do have to sign it. And so all wills must be signed, and you really should date it. I think there might be some loopholes where you're not actually required to date a will in certain circumstances, but I'm not 100% on how that works. Generally, date your will. It's best practice to date your will, because if you ever change your will in the future, like write a brand new one and say all of my previous wills are now null and void, and this one is my new one, and this is the one that's going to take precedence. Well, you need to have a date on all of your previous wills to be able to prove which ones came first and which ones came later, right? So always put a date on your will, even if you live in a state where you don't have to. And then in California, you don't actually have to have a will notarized. It's not required to have a notarized will if you have two witnesses. But sometimes people like to, just to have extra, comfort, mental comfort, to say, you know what, I got it notarized. I know there's no question about the validity of it there. You can do that, and a notary public can do that for you. And in California, I think it only costs $15 to have a notary stamp a document. So those are the requirements for a will in California. Of course, I'm addressing California specifically. We're in Butte County, and if you happen to move to another state or be watching this from another state, you'll have to look at what's valid for your state. There are some special cases for wills. So a holographic will is the one I was just talking about a second ago, where you can entirely handwrite your will. It's called holographic will if it's entirely written by hand. It can have no typing. It has to be entirely handwritten by you. It has to be dated and signed by you. And if you do that, that is a valid will. You don't have to have any witnesses. You can do everything by hand on your own. My first will that I did for myself, I did a holographic will because I knew that would, one, that it would be legal and valid and I could do it. And two, I wanted to, it was when my son was going to be born, I said, well, if I'm going to have a child, I probably need to have a will. And so the first thing I did was I created a holographic will. I said, here's what I'm going to do. And then later I decided to get something more permanent, right? But that was the first thing I did. And so you can do that. If you want to have a holographic will, you absolutely can do that. Generally, most attorneys are going to recommend against it because you're doing it DIY, right? You're doing it yourself. There's a lot of possibility for mistakes. And it's you might want somebody else to look over it and someone else to be aware of it. And generally, it's a good idea to let people know that they're included in your will, because if you pass away and no one knows you had a will, who's going to be that executor who's going to take it to the court? If no one knows about it, what happens, right? So generally, it's a good idea to have a typed out will, get witnesses to sign it, you to sign it. And one of the things I didn't mention actually is the witnesses who sign, who like witness you signing the will, they have to be disinterested parties, which means they can't be beneficiaries of the will. So if you're going to leave all of your property to your sibling can't be a witness to you signing the will. Generally, if they're not direct family members, they're probably going to be considered disinterested. As long as they're not a beneficiary of anything in the will, they're disinterested parties. So a friend is usually a good person to have as your witness. There's also a thing called a statutory will, and this is specific to California. In California, they have a state statutory will, which is essentially like a fill in the blank form that you can use in California, but you cannot change it at all. You can't cross out a line. You can't say this instead of this. You have to use the statutory will as is and just fill in the blanks with whatever it asks you to fill in. You can do that if you want. You still have to have two disinterested witnesses. You still have to date and sign it, and that's fine. And you can do that, and it's totally valid in California. And if you want to do it that way, you can. It might be, once you read it, you might realize, what, the statutory will doesn't actually do the things that I want it to do. Maybe you have different ideas for your property. So it might be better to have, an attorney draw up a will specific to your wishes. So some considerations when creating a will, some things that people make mistakes and don't even realize it. There's a concept there's a legal term called pretermitted heirs, and that means when somebody is forgotten about in a will. And the most common way that this happens is you say, leave my property to my son Johnny, and then a couple years later you have a daughter Susie, and she's born a little while after, and you never update your will. And your will says, leave my property to my son Johnny, and doesn't mention Susie at all. And had you updated your will after Susie was born, you would have wanted to include them both. You would have rather had said, leave my property to my two children, right? And not said specifically Johnny. But now your will says, leave my property to Johnny, and it doesn't mention Susie at all. Well, or did I say Susie or Sally? I don't remember, but it doesn't mention the other child at all. And so now Susie is a pretermitted heir, meaning that she was forgotten. But had you remembered, you would have wanted to include her. And so now there has to be an argument in the probate process for should Susie be included. And generally in California, unless there's some other evidence to the contrary, Susie will be included. And so the judge will likely say, all of the property that's being said to leave to Johnny needs to be split evenly with Johnny and Susie. And that may be what you want, and that may be fine, right? And so you're like, I'm not worried about the pretermitted heirs. I want to leave everything equally to all my kids. And if I leave one out, then the court will just let it, let them split it all evenly. Yeah, maybe, but that's a lot of hassle. They have to go to court to make to make their argument to the judge. It would be a lot easier to update your will after your children are born, or to not name specific people like by name and say, to my children and any future children I may have, right? We want to be very cautious about the language we use in our will. And so we also use things like, should my children predecease me? That's a language of a legal term, I guess. Should my children die before I do, then my property should be left to any grandchildren I may have. Should I not have any grandchildren, then it should be left to someone else or a charity, and then you just essentially have, backup beneficiaries. It's actually called contingent beneficiaries. You have a contingent beneficiary in case the original person who you want to leave something to is not around to receive it because they passed away already, or it's actually possible to disclaim inheritance. They may not want it for some reason. There's all kinds of things that could go on. So having contingent beneficiaries, backup people, and be vague about the specific of the backup people. So leave it evenly to all my children is perfect. Now you can, if you, let's say the pretermitted heirs issue comes up and you want to leave all of your property to Johnny, and you specifically don't want to leave anything to your daughter Sally, you shouldn't say that. People sometimes don't feel comfortable saying that. It's called disinheriting someone. You say, I don't want them to inherit anything. You say explicitly, to my daughter Sally, I leave nothing. That's okay. You can say that. It's your will. You can say whatever you want. It's your property. But a lot of times people don't feel comfortable doing that. And so you might want to leave them maybe like a small amount, just to say like, hey, here's, to Sally, I leave $200. To Johnny, I leave $2 million. Kind of awkward, but you can do that, and your own family dynamics are up to you, right? So you can decide how you want to do that. A good thing to do after someone passes away is to get copies of the death certificate. So in California, the county will take care of creating a death certificate, and you can get one, and you should get multiple copies. I think the general advice is to get 10 copies of death certificates, although I've dealt with a few deaths in my life, and I've never needed to use 10. So generally it would be things like taking it to a bank, providing one to an insurance company to show if there's life insurance, maybe if there's something related to like Social Security or a pension, those kinds of things, you might need to provide death certificates, and you can get copies of them done. 10 is probably enough. I think that's like the baseline suggestion that everyone does, and that's fine. But you want to make sure you get copies of death certificates to give to anybody who you need to prove that this person passed away, right? People who are owed money or people who owe you money so that you can get that as a beneficiary. Naming specific account numbers and policy numbers in the will is also a good idea. I have a document in my household that is like our family filing. I don't remember the actual term, but it's like the family filing that we have for all of our accounts. So our bank account information is in there, our life insurance policy information is in there, so that if one of us were to die and someone else who's not familiar with our family finances were to be the executor or being taken care of these things, they can go through that folder and say, okay, I can call this life insurance company and tell them this is the policy number and provide them with a death certificate for Jacob who died. And then that life insurance can get paid out to the beneficiary that it's supposed to, right? So keeping all of that information available, you can name specific accounts in your will as well. You can say the life insurance policy is already handled because life insurance doesn't go through a will. But you can say the bank account at Wells Fargo with bank account number 12345 should be entirely given to split amongst my children. That might be a good way to phrase that. You can do however you want to do it, but if you name specific numbers or account numbers or specific property, that is helpful rather than saying, my bank account, and then someone has to figure out, what bank account, what are they? But you can also run into issues with, you say this bank account number, and then later you don't have that bank account anymore, you close that account, and then you die. Well, then people are going to try to find that bank account number. It's going to be gone. Maybe you moved that money to a different account and didn't update your will. It can be a little bit messy, and you have to just kind of phrase it the way that it makes sense depending on what your life looks like. And I can't tell you that information. You have to decide for yourself what makes the most sense. Last piece to consider on here, don't forget the debts that you have. So you're going to have to pay your debts out of your estate before you can bequest assets to someone. You have to pay off the debts that you have from your estate. And so don't say from my bank account, leave $1 million to my children if there's $1 million in your account, but you have $500,000 in debt, because you're not gonna be able to leave that $1 million. You'd have to just say, leave the balance of my accounts to my children, whoever they may be, and then they'll get whatever's left over after the debts are paid. You can also revoke a will at any time. If you say, you know what, I wrote this will, I want to get rid of it, you can eliminate it. You can do that. You can write a new will, a brand new will that says revoke all my previous wills, and this is my new will, and it takes precedence over everything else. As long as you've dated all your wills, no big deal. You can absolutely do that. And so you do want to make sure you include some language. So you put the new date of the new will, absolutely, so that the previous ones can be identified as any date prior to February or whatever date that you're writing it. You say that's going to be my current will, and every will written before this is now null and void. That's fine. And then you want to make sure you specifically say that too, because there's other ways to modify wills. And if you want to actually revoke any previous wills, you do that specifically. Say, I revoke all previous wills, and this is my new will. Or there's a thing called a codicil. A codicil is an attachment to a current will, and some attorneys don't like codicils, and I don't blame them. A codicil says, I'm going to attach this new thing to the current will, and it makes a modification to the will in some way. And that is allowed to be done. But if you start attaching a bunch of codicils to a will to start making all these modifications every year, you're going to get a pretty complex situation, because you have a codicil modifying something, and you have another codicil modifying that codicil, and it's messy, right? So it's possible to be done. Maybe think about just revoking a will and starting fresh, right? That's a little bit more clean. You get a clean break and you say, let's just start over. If you do a codicil, it needs to be signed like witnesses, or it needs to be signed by witnesses like the original will does. And so you'll have the original will with witnesses signing it. And then you add a codicil with its own witnesses. And then if you start attaching a bunch of files, it starts getting to be maybe a good idea to initial everything, right? Any changes, every page, you initial every page, just so that there's a clear, like, I did see this page and I did approve that this page is in there. You don't want somebody later on switching out pages in the middle or something like that, although I don't think that happens very often, but that might be something you might think about. And so also, if you're going to have an attorney file or create your will for you, the attorney's probably going to want to keep a copy. You're going to want to keep a copy. And then that way, there's multiple people with copies of the same document. It's much less likely for anyone to get a little creative, right, and try to change anything. There's another type of will, and so since we're in the section of talking about wills, I said there's the thing called a pour-over will, and it's a special kind that goes along with trusts. But I'm going to talk about trusts first, and then we'll come back to what a pour-over will is. But it works connected to trusts. So let's say, what is a trust? And you probably heard of somebody like a trust fund baby, that kind of thing. You think of trust as being, really wealthy people, but a trust actually works for, you don't have to be a wealthy person. You just have to have some assets that you want to set up in a trust. There's a few different kinds of trusts. I'll talk about them in just a minute, but generally, if you want to use a trust, or if you want to avoid going through the probate process of a will, you can create a trust, which for people who, if you don't really need to know the legal rules around it and stuff, you just need to know what a trust is. I kind of think of it like a shell company that you can create that can do things. That's not technically true, but it's a good way to think about it, I think, is that you can set up this shell that can do things, and you can put assets into it, and then that shell company can then distribute those assets to whoever you want them to. And it's almost as if it's like an arm's length extension from you. And so it's not your property anymore, it's the company's property, right? That trust's property. A trust has to pay its own taxes. There are trust taxes. And so that is the same kind of logic around like a company. And so you can set up a trust with its own rules. There's a trustee, a person who manages the trust, and you can be the trustee of the trust you create if you want to. But then when you die, then somebody else is going to have to administer it. So there's some rules around that too. But a trust allows you to avoid probate, right? You don't have to go through the court process. You don't have to make anything public. A trust can be a private company. No one can know what's in it unless you want them to know what's in it. And that's pretty useful. And especially if you have lots of assets, right? The reason trusts get the kind of reputation of being a wealthy person's thing is because if you have millions and millions of dollars and lots of houses and lots of other property that you want to leave to people, you can put it all into a trust, have the trust maybe sell it, take the cash, and then distribute that cash. The trust can say, don't leave this to this person until they reach age 47 or something like that. It doesn't have to be, I think in movies, we always see someone turns 18 and all of a sudden they inherit millions of dollars. That's a movie myth, right? You can leave things to people and tag it as they don't get it until they reach age 42 or reach age 37 or reach or until they have been sober for 2 years, right? You can put some rules around trusts and how they work. And so the trustee who's managing the trust will be responsible for making sure that those rules are followed. So different kinds of trusts. Well, first off, the rules. So a trust has to have assets. There's going to be a trustee. There's going to be some rules surrounding it. But the different kinds of trusts are living trusts and irrevocable trusts. So a living trust is a revocable trust. It's one that you can control when you're alive. And then someone else will control it after you die. So you've probably heard of a living trust before. That's one where you create it. You can put things into it while you're living. You can use it to manage your assets a little bit. And then when you die, that trust will then do something, right? According to whatever rules you set up. And that's fine because you can manage it while you're alive. It doesn't really come with much tax breaks and much tax benefits. Because you are controlling it, you have what's called constructive ownership or constructive possession of all of those assets, even though they're within the trust. And so if it makes money, it's still your money, right? And so you still pay taxes on it. So not super helpful, but can be for just cleanly making a break of who owns what and where. It can be useful. And there's a lot of situations which a living trust is useful. But there's also another kind of trust called an irrevocable trust. And that's one where you transfer money into it. And once you transfer money into it, it's done. You can't bring it back. It's out of your hands. It's gone. And that's really useful for tax scenarios in which you want to say, I don't have that property anymore. I don't have to pay taxes on it because it's not my property. The trust will take care of that. Another useful way to use an irrevocable trust is the debt person, the creditor who I owe money to, can't come after this irrevocable trust because it's not mine, right? I owe money to this person, and sorry, I created this irrevocable trust and I can't pay you now. That may or may not be an ethical way to go about it, but that is an option. So those are some of the benefits of an irrevocable trust. There's other kinds of trust too. A remainder trust is one where you can leave property to family or leave it to whoever. It doesn't have to be family. You leave property to someone and then they get to use that property during their lifetime. And then when they pass away, whatever is left in that trust can get left to someone else, right? You have like a secondary backup person. So you can give someone a life estate, it's called, where they're allowed to use it for their life. And then when they die, then someone else gets it, and doesn't necessarily have to be their heirs. They don't actually own the property, it's the trust's property. And so the person who's using it can just get the benefit of using it, but they can't themselves leave it to someone. That's kind of, creative a little bit. You can do things like that. There's a specific kind of remainder trust called a charitable remainder trust, where you say, here's all of my property, I put it in my charitable remainder trust so that my children can use it for their lifetimes, but they don't get to keep it. So once my children die, then everything in that trust gets left to my favorite charity. If that's something that's important to you, you want to have a legacy around, giving to nonprofits or a worthy cause, you absolutely can do that. And then there's a thing called an irrevocable life insurance trust, an ILIT. And this might not actually be that useful for most people, but although there are scenarios in which it does become in handy. So an ILIT is one where you can put life insurance into the trust to be left to somebody. The problem with that is that, one is life insurance already is going to be left to a beneficiary tax-free anyway. So if you have just a standard life insurance policy that you're going to leave to someone as a beneficiary, don't bother, you don't need to worry about putting it in a trust. Generally, talk to an attorney for your own specific circumstances, but generally, if you have a life insurance policy, you can just have that life insurance policy existing without a trust, and then when you die, that life insurance will pay out to the beneficiary. Maybe it's your spouse, maybe it's your kids, maybe it's someone else, but they'll receive that money tax-free regardless. So maybe an ILIT might not be for you, but maybe you want to leave the life insurance policy to grandkids or something, and then there's like generation skipping taxes you have to worry about and these kinds of things. That's an area where you're going to want to talk to an attorney for your specific needs. Okay, so now that we've talked about trusts, let's go back to the idea of a pour over will. So a pour over will is one where you say everything else gets left to my trust in your will, and that's your will. That's the whole will. The entire will is everything else I forgot gets put in my trust. And like famous example, I guess Michael Jackson did that. He used a pour over will where he just said, all of my assets that aren't already acquired or aren't already put into a trust get put into my trust. One of the benefits is trusts are private. They are not publicly disclosed. You can create a trust if you want. No one will know about it. But wills, when they get put through the court system, do become public. And so Michael Jackson, for example, everybody who is a journalist wanted to know what assets Michael Jackson is leaving to who. And so when the will became public, because it went through the probate process, they go look at the will, and now it's public information, and it says, all of my assets go to my trust. And that's it. And then the trust is secret. Well, it's not secret, but it's like, it's not public. And so the people who are involved in the trust know about it. And so then they'll get, inherit whatever it is that they inherit, and the journalists weren't able to figure that out, right? So that's a good use of trusts, right? And a pour over will is one where you just say, it's like, so you don't forget anything. You say, leave everything that I own in my trust. And generally, all the things that you're really, conscious of and want to make sure you get distributed the right way will already be in a trust. And so the pour over will is just for the things that you acquired towards the end of life. Things that, you put everything that's important, your homes, your property, your everything else into a trust already. And maybe you're 90 years old and you say, I'm going to have a pour over will for anything that I acquire in the next few years before I pass away. And you just do that. And then the actual property within the pour over will that gets moved to the trust is usually not very much, right? It's not like lots and lots of assets. All your assets are already handled by the trust. So it can really only be done through a living trust, because irrevocable trust would already be completely closed and finalized and done while you're alive in order for it to be irrevocable. So you just do pour over will goes to a living trust, and then that's just kind of a clean break so that nothing gets forgotten, right? You can imagine a scenario in which you put a bunch of things in your trust, your living trust or an irrevocable trust or however, and then and you don't have a will, and in the last few years of your life you start acquiring some wealth in some way again, and then now you don't have a will, and so now you have to deal, or your family will have to deal with you what's called being intestate. And so the word testamentary covers is what we're talking about here. And when you go through the probate process of your will, but don't have a will, if you don't have a will at all, then it's called passing away or dying intestate. And the California court system has a policy for how they process someone dying intestate, but it might not be the way that you want your assets to go. There's a thing called consanguinity, which means how your assets get passed amongst your heirs. And it could go to your spouse first, it could go to your kids, it could go to your parents, it could go to your siblings, and they have a specific path that they follow in order to distribute your assets. And depending on who's still alive, they'll distribute it to whoever's next in line. But you might not want that. So you don't want to necessarily pass away intestate. If you can help it, a pour over will is a perfect way to make sure that doesn't happen. So I talked about life insurance just a minute ago about ILITs. Another thing to consider is life insurance is there to protect beneficiaries of yours, whether it's your family or any dependents, people who depend on you. Might not necessarily be children. Some people can depend on you who aren't your children, but whoever it is, it's people who are dependent on your income or dependent on you. That's what life insurance is for, right? To pay them when you pass away. Life insurance doesn't directly become part of your estate in general, although it's possible to make it part of your estate and go through probate. That's usually a bad plan. The best way to do it, usually, would be to have your life insurance policy pay to a specific beneficiary when you die, and they will receive that money without taxes. And as long as you've named your beneficiary and you've paid your premium, so your policy is actually valid and it didn't expire or anything, then when you pass away, your money gets left to that person tax-free, and it can be millions of dollars. And you have millions of dollars tax-free to the beneficiary after you pass away. And that's not uncommon, actually. And that's something that you could set up. But I've seen mistakes in financial planning done where someone will leave life insurance to an estate of some kind, whether it's a trust or they don't have a beneficiary at all. And so the policy gets paid out to their estate and then becomes taxable. And so millions of dollars going from being tax-free millions to a bunch of tax having to be paid on that. And you can imagine if it's millions of dollars, you're in the top tax bracket. That's not something you want. So by naming a beneficiary and making sure that you paid your premiums, you can avoid taxes that way. So make sure that you name a beneficiary, because if it ends up going to your estate, it can be subject to creditors who are trying to come after that money, right? So lots of mistakes can be made that way. So that's kind of a basic primer on estate planning. And so I'm hoping that you got a lot out of that. I want to reiterate that that's clearly not everything there is to know about estate planning, and you're going to want to know things that are specific to your scenario. So the three categories of professionals that you might want to consider talking to when it comes to estate planning would be an estate planning attorney. And there are a number of them. I won't name them for the sake of being fair. I won't name anybody, but in Butte County and Chico, there are a number of estate planning attorneys who are excellent at what they do. And I know a handful of them personally. And that would be maybe the first step. You can also talk to a financial planner, and I happen to know quite a few financial planners in the Chico community who are all very good at what they do and very well versed in estate planning needs. And so those are available as well. And many of them will do a free consultation to let you know how they could help you. And then if that works, you can say, perfect, let's do this, let's make this happen. And then the last, not necessarily last, but the third on my list of checking off these names would be somebody who's an accountant, like a CPA. They can help you to figure out the tax implications of when you leave things through probate process or those kinds of things. So estate planning attorney, financial planner, or tax accountant, all three of them can help you out. And it really depends on the specifics of your circumstances. So I'm going to leave that to you to decide. But I need to mention Butte County Reach, our Butte County Library Reach programming. In addition to the financial literacy workshops like this, SCORE is a program for people to learn more about business and financial literacy topics, and they do a series as well. Also, some of them are on Fridays, so there's probably one today. And then Chico Start, which is our downtown business incubator, also does a series of workshops through Butte County Library's REACH program for startup businesses, how to make your business more successful, how to hire employees, how to do all those kinds of things to grow your company, how to market effectively, all those kinds of things. So with that, I thank you for watching the video. I hope you learned something from it, and I will see you in the next one. Have a great rest of your day.